Good afternoon, and thank you for hanging in there. I'm the token lawyer in the team tonight, and my job is to talk to you a little bit about an evolving legal principle that you will not find widely discussed in any legal literature, very rarely in cases or legislation at the moment, but which potentially has very substantial implications and relevance for the topic of PAD that we're discussing today. This principle has begun to be debated by lawyers, both national and international lawyers, in recent years, and as a result particularly of some work by a French environmental law scholar, Michel Prieur, who drew attention to the fact that although we put in place a vast array of environmental laws that serve to advance the cause of conservation, in the end we still seem to be losing the battle. If we look at particularly the figures and the statistics around the loss of biodiversity, and he asked the question, should there not be some sort of fundamental norm or rule which has the effect of preventing governments from moving backwards, from moving in a regressive way by lessening the levels of protection that are afforded to the environment generally, and I think we say to protected areas specifically. As a principle, when the lawyers turn their minds to how you might frame this as a legal concept, some thought has been given to basing it upon an extension of the notion of human rights, because we understand now and accept that when human rights have been recognised by international law, no nation can abrogate those rights. They are fundamental and they cannot be detracted from. So by extension, and this is partly where Michel Prieur based his argument, if we have rights to a clean and healthy environment, rights for nature even, then those equally should be subject to the same level of protection from the law by not being able to be abrogated. And this statement here talks about how the World Commission on Environmental Law in 2010 really based its first discussion of this principle on that particular foundation. More recently, in Jeju in 2012, a very important resolution was adopted there at the World Conservation Congress, in which a slightly different iteration of this non-regression principle was advanced. One in which the key element of it, the key substantive component of this principle, is the idea that there should not be allowed any backsliding or regression on the level of protection that is afforded by governments to the environment. Now this is a rather different proposition. Instead of linking the principle to the protection of human rights, it is actually broadening it by saying any measure by a government that might move backwards the level of protection that is currently afforded to the air, the water, or our national parks, our protected areas of itself, might fall within the embrace of this principle of non-regression. That's a very bold statement, I might add, and as a lawyer, it's not one that I'm suggesting to you is firmly entrenched in any legal system at the moment. Interestingly, the European Parliament, in the lead up to the 2012 conference, Rio Plus 20, suggested, I think rather boldly again in terms of legal precedent, that international law already forbids repeal or amendment of laws designed to protect the environment by governments. They didn't win that argument in Rio, I might add. Their efforts to have a statement to that effect reflected in the declaration from the Rio Plus 20 conference did not succeed, and that indicates that this is still a work in progress as a legal measure. Finally, though, I note that our Director General, Julia Martin-Lefebvre, in her statement released in journal Science just a few days ago, herself identified the need for the adoption of the principle of non-regression in environmental law in the context of the matters we're discussing at this Congress. And I think this is where the recognition is beginning to grow amongst those who are advocating for protected areas, and for conservation, for the protection of biodiversity, that increasingly we find through all the array of circumstances that have been described to us by the previous speakers, a good reason for invoking this principle, at least in a policy and an advocacy sense, even if we cannot say that at this stage it has a firm legal foundation. So when it comes to how this principle works in practice, I think one of the great difficulties for it is that whilst it has a tremendous relevance in the context of PAD, of the various types of stepping backwards and backsliding that we've been discussing to date, in practice, one of the difficulties that we face is that as a legal principle, it's very hard to see how governments would accept that they are, in a sense, tied in terms of the hands of their parliament with respect to making laws in the future. That they can be precluded from passing legislation now or having a principle in operation now which limits the ability of a parliament or a congress in the future to change that law in some way. And that's what we call in law the principle of mutability, the idea that laws are mutable and changeable from time to time, which is in fact a very good thing in terms of the advances that we achieve as different social understandings are reflected in the law. But in this case it presents a bit difficulty. What I want to do now, just very briefly for a couple of minutes, is talk about the relevance of this principle in the context of PAD and protected areas. If a principle of non-regression were to be reflected in a constitution, and it's I think not easy to point to good examples of that at the moment, but if it were, that would be one basis in which to actually centre the principle within a legal system. But that is not, at the moment, something that one can suggest has happened. However, it is the case, in fact, already that in some ways protected areas legislation often poses limitations on the way in which the rules that relate to a protected area can be changed in terms of downsizing, etc. To expressly incorporate a stronger principle in protected areas legislation that states that no government shall take action under this legislation that would result in a lessening of the conservation values and status of protected areas would in fact be a quite reasonable form of provision to incorporate into legislation to reflect this non-regression principle and to give it some more effect. I think also in many cases governments require that regulatory impact statements be prepared to demonstrate what the impacts of legislation will be. This is a very common process now across countries. My thinking here is that why not ask them to also identify where legislation would have a regressive effect in terms of levels of environmental protection. I was very interested in what Ian Craig had to say about trade-offs, and I think he raised a number of very proper question marks around the possibility that we could use this idea of changing the status of parks in order to get other areas, other protected areas into the system. And in that sense, if you go back to the ICC resolution, it does, in a sense, open the door to this, when at the end it said that there should be no regression except where flexibility enhances conservation. And the question is, how could you apply this idea of flexibility recognised in that resolution in this context? Recently, an article in Nature suggested that, in fact, within Australia, we could increase the number of vegetation types that are protected in ways that would address some of the issues that Ian was pointing to about lack of representation by replacing the least cost-effective of protected areas with others that have higher levels of protection. And that's a good theory. Whether it would work in practice is, of course, the point that Ian made. I think that in that sense, I'd say that there's still a lot of work to be done, but it's not impossible to contemplate such a strategy. The IUCN itself has produced a report with the Mining Council, the International Mining Council, recently, on biodiversity offsets. And I'll leave you with this thought, that in a sense, there is a lot to be learned, although I don't suggest there's a direct parallel here. But there is a lot to be learned from the experience today with biodiversity offsets. And as Ian pointed out, in many cases, we're not getting the kinds of outcomes that we should be achieving. But if we were to try to take our learnings from the offsets context, then I think there are certain conditions, if you like, that could be attached in order to promote an effective, if you like, swap or trade. So these are sort of principles I've just taken out from a very recent paper by Australian colleague Rachel Walmsley on the question of best practice for biodiversity offsets. If one was to adopt the sorts of criteria that are presented to you on the screen there, and they could be enforced, perhaps there would be at least a framework within which we could think of replacing some of the lesser value areas for higher value ones. Thank you very much.